14. Evidence. The rules of law are divided into two classes, those which prescribe the rights and obligations of men, and are known as rules of substantive law, and those which relate to the means of enforcing these rights and obligations, and are called rules of adjective law. The law of evidence belongs in the latter class, as it relates to the use of evidence, the rules for its exclusion and for presenting it in court. What is evidence? The law of evidence should not be confused with evidence itself. The latter includes all the legal means, exclusive of mere arguments, which tend to prove or disprove any matter of fact that is submitted to judicial, and in other words, it is the means by which disputed facts are proven in a court of law. Sometimes testimony is used synonymously with evidence, but actually testimony is only one form of evidence and does not include writings, documents, or real evidence which may be used in the course of a trial to establish proof. Judicial notice. As just stated, the facts in issue are established by means of evidence, but there are certain facts which do not have to be proved, because they are so well known or so easy to ascertain that it would be a waste of time to be obliged to demonstrate their accuracy. Therefore, it is a rule that the court will take judicial notice of certain truths, such as facts of governmental concern which relate to national or state government, the jurisdiction and decisions of its own court, the phenomena of nature and the physical sciences that have become such a part of our habits of thought that they are not disputed, such as the nature and effect of heat or cold. Matters relating to customs, habits, and the lives of mankind do not have to be proved if they are facts which are universally recognized. For example, that a telephone will conduct messages from one point to another, or that automobiles have largely replaced horses in our cities. In a case which was decided for the plaintiff and later reversed, it was said to be common knowledge that a moving picture theater necessarily operates in partial darkness. The action was for personal injuries that were received when a patron of the theater became dissatisfied with her seat and moved to a place she thought was more desirable. She claimed there was no usher to assist her and that the theater was not properly lighted. She knew she had to go down steps to get to the other part of the theater and admitted that she could not see these at all. On an appeal, the decision was against her because she was negligent in moving when she could not see. Facts admitted by the parties by means of written pleadings require no proof, as they are acknowledged. Also, any further admissions which are made by either party in open court, in order to expedite the trial when proof would otherwise be needed, are in the same class. The burden of proof. Before considering the form and nature of evidence and the facts which will be excluded or admitted, we need to understand in some detail the systematic method of presenting evidence, and the fact that the person who makes an allegation in the pleading has to prove it. That is, according to legal rule, the burden of proof rests on the one who would be defeated if no evidence were given on either side. Long years of usage have established this as a definite rule in trying cases. Therefore, if the plaintiff alleges certain facts in the pleading which the defendant denies in the answer, the plaintiff must assume the burden of proof throughout the trial, but the defendant at times may have the burden of going on with evidence to support his denial of the claim made by the other party. The following case will illustrate this. Plaintiff alleged that he was owner of certain property, and that in June 1937 he leased the premises, in writing, to the defendant for such time as would be necessary to cultivate and gather a crop of cotton then growing on the premises. That defendant had gathered the crop of cotton on or about the 25th of July 1938, but still held possession of the premises against the will and consent of the plaintiff, though plaintiff had made a written demand for possession. The complaints also alleged that the defendant did not have any lease on the premises nor any right to possession. Defendant answered, admitting plaintiff's ownership of the property, that it was leased as plaintiff alleged and the original lease had expired, but he claimed possession under a new oral lease. The real issue at the trial was whether or not there was a new oral lease, and the jury was instructed that the burden of proof was upon the plaintiff and never shifts, although the burden of procedure may shift, as in this case, when the burden of proving a new lease was on the defendant. The verdict is given according to whether the allegation is sustained or denied. And if the evidence is evenly balanced, the verdict must be against the person who has the burden of proof, because he did not establish his allegation by a preponderance of evidence, which is the test in civil cases. In criminal cases, the burden of proof is on the state, and it must be shown beyond a reasonable doubt that the accused is guilty. Presumptions. There are certain presumptions indirectly connected with the law of evidence which are not substitutes for inference, but are definite rules based upon experience or public policy and imposed for the convenience of the jury in order that it may be easier to determine the truth. McKelvey states that these rules have developed through 4 stages. The first stage was that of mere inference, which was permissible. The second stage was a disposition on the part of the judge to advise the jury as to the desirability of such inference. The third, instruction that such an inference ought to be drawn. And, finally, a rule that the inference was a necessary one which the jury was bound to draw. In this way it became equivalent to saying that certain things are true, though any presumption is rebuttable and may be disproved by proper evidence. Some of the best known prima facie presumptions are absence of a person for 7 years, without communication with those who would naturally hear from the person if alive, gives rise to a presumption of death. Evidence that a child is born during marriage is sufficient to establish the presumption of legitimacy. Evidence of mailing a letter is on its face sufficient to prove receipt of the letter. A case in point concerned 2 promissory notes payable with interest at 6% which plaintiff tried to collect from defendant. 3 letters were introduced as evidence, one written to defendant on July 27, 1935. A second followed this on August of the same year. The third was an answer from defendant. The first letter was returned because of an incorrect address and was forwarded to the new address. The second letter did not make a demand for the money but asked for a reply to the first letter in which a demand had been made. In reply, defendant wrote of his hard luck and inability to pay as agreed but proposed that the payment should be made over a period of time. Plaintiff accepted the proposal. At the time of the trial, defendant claimed that he did not receive the first letter, though there was no evidence offered to support this. The decision was that his letter was an answer to the first letter, for when plaintiff testified that he wrote and mailed a letter to defendant and there was no evidence that the letter was not received by defendant, the presumption was that the letter was written and properly posted and therefore was received. Classification of evidence. Evidence may be classified as real evidence, written evidence, and testimonial evidence. The last mentioned may be either direct or circumstantial. Real evidence. Real evidence is a tangible or physical object which the jury can see in court, such as a gun that has been used in a murder, or a hand which has been mutilated by an accident. This type of evidence is sometimes called demonstrative evidence. A ruling which permitted the exhibition of an injured shoulder and plaster cast was held not to be an abuse of the trial court's discretionary power. In a personal injury suit, land may be the subject of the controversy, and sometimes it is necessary for the jury to inspect the property in order to obtain real evidence. A writing or document, when treated as a physical object and examined in court, may be regarded as real evidence. If its existence is material to the case, its presentation is proof just as the presentation of any article would be. In a more restricted sense, writings are looked upon as the expression of certain operative acts which pass something from one party to another. A will or a deed is an example. Proof of their authenticity and the manner of producing them in court have presented difficulties at times. Writings. The contents of a writing must be proved by the introduction of the writing itself if it is in existence, as this is the best evidence available. But if the document is lost or destroyed, copies which have been compared with the original are admissible as secondary evidence. When the carbon copy of a written contract, the existence of which was in question, was offered without proper identification as a duplicate of the original, and without adequate explanation of the failure to produce the original, it could not be accepted as evidence. Writings are proved in 2 ways. Attested documents are proved by the attesting witness if alive, unattested documents by evidence that the handwriting of the maker is genuine. Public records and court records can be proved by certified copies, as the originals are not as a rule available for court purposes. Testimonial evidence. Evidence secured by means of witnesses is of great importance and may be either direct or circumstantial. The first is the direct testimony of one who saw or heard certain things which prove the fact in dispute, while indirect or circumstantial evidence establishes a fact from which the fact in dispute is inferred. An example of this is shown in the trial for the theft of an automobile. A has an automobile stolen from his premises, and if B can testify that he saw C go into A's garage and drive the car out, that is direct evidence. However, the theft of an automobile is not usually made as boldly as that, so if it can be shown that simultaneously with the loss of the car, C is absent from town, and he is located in a distant city with a car of the same make and number as the stolen car, It can be inferred from all the circumstances that he took it, though no one actually saw him do so. It is said that circumstantial evidence is not as strong as direct evidence, but many times it is the only evidence obtainable. Evidence of former acts not admissible. The same case can be used to illustrate a further rule. It might be helpful in proving this theft to show that Chad previously been guilty of appropriating things belonging to others, but this evidence is not admissible, for the law does not allow the inference that a person who has committed a criminal act once is likely to do so again. This might seem to be the logical and relevant inference about a person's character, but the commission of one crime is not admissible to prove another, and character cannot be proved by former acts. When character is an issue, it is proved by evidence of the general reputation of the person in the community, as it is necessary to exclude any evidence which might confuse or prejudice the jury. This rule aids the accused and gives him a chance to safeguard his rights. Hearsay evidence. In order to be admissible, evidence must be competent as well as relevant. And when applied to evidence, competency relates to the form of presentation. The general class of evidence which is not admissible because it is incompetent is hearsay evidence. But no sooner does the law of evidence rule that hearsay is inadmissible than it turns about and makes exceptions. As a general rule, statements, either oral or written, which are made by persons who are neither parties to the suit nor witnesses, are not admissible. In other words, if a person cannot state of his own knowledge that a fact is true, but only that someone told him so, this is hearsay. The reason for excluding this type of evidence is fairly obvious. When a person is testifying before the court, he is under oath to speak the truth and is subject to cross-examination. But this is not the case with hearsay evidence, for the person who made the original statement is not before the court, is not under oath, and his testimony can neither be refuted, explained, nor investigated by cross-examination. To illustrate, as sues B for the price of a watch which he sold, B offers the testimony of C, who says D examined the watch and said it was not in good condition anyway. This is inadmissible, as D, the person who could give the information, is not before the court. Hearsay is admissible when the circumstances tend to ensure the truth of the evidence, or because the declaration of certain parties who cannot be witnesses is the best evidence obtainable. Confessions and admissions are strictly speaking examples of hearsay which are admissible as evidence, for in both of these statements the person makes an acknowledgement which is against his own interest, and it is not reasonable to suppose he would do this unless the statement were true. Concessions. A confession is an acknowledgement by a person that he is guilty of the crime with which he is charged and is therefore admissible only in criminal cases. In addition, it must be shown that the confession is offered voluntarily and is not the result of promises of favor or threats and acts of torture, which was the ancient method of exacting confessions. The torture was often so severe that innocent persons, in order to escape it, would confess crimes which they had not committed. Admissions. An admission is a statement or act which amounts to an affirmation of some fact which is material to the issue, and which operates at the time of trial against the interest of the party making it. It may be used in either criminal or civil cases, though in the former it is not as inclusive as a confession. Various declarations are an exception to the rule against hearsay because they are the best evidence that can be obtained. Some of these are: 1. Declarations against pecuniary or proprietary interest are admissible when made by a party who has since died. An entry in a book which shows the receipt of money is an example of this. 2. Dying declarations are admissible when made in the expectation of death, because it is assumed that under these conditions they will be true. 3. Declarations concerning matters of public interest are allowed as proof. Ancient documents and public records are admissible on the theory that they are likely to be correct. 4. Entries in the course of business, which include not only commercial business but professional services as well, are allowed because of the same assumption that they are likely to be correct. 5. Testimony and declarations made under oath may with certain qualifications be presented as evidence when the witness is dead or physically or mentally incapable of being present. 6. Declarations relating to pedigree and the testimony of a person relative to his own age, though hearsay, are admissible facts because they are based on family tradition. An interesting example of this rule is the following. By the law of Oregon, property left by an illegitimate child goes to the state if the person dies without a will. In an action brought by the state for the estate of Arthur W. Wakefield valued at $9,000, the following facts were brought out. Two women claimed to be his half-sisters and his sole surviving heirs at law. The state admitted that they had the same mother but claimed there was no proof of a marriage between the mother and father of deceased. Testimony of a half-sister was admitted, and she said the parents were married, and soon after the marriage the father of the deceased joined the army and was killed. For some reason her mother resumed her maiden name of Wakefield and brought her son up by that name. She later married the father of the two half-sisters who claimed the estate. This evidence was admitted for a daughter's testimony concerning her deceased mother's statements about the circumstances of her marriage as affecting the legitimacy of her son, is admissible as an exception to the general hearsay rule since it relates to history and family tradition concerning pedigree. Witnesses. The judicial inquiry should be as complete as possible. Therefore, anyone who has knowledge of the matter in controversy can be summoned to appear as a witness and is not excused without good reason. In England, the early practice was to exclude many persons from this duty. This was largely a result of the social and political life which fostered inequalities between the sexes, and between those of different religious and political beliefs. Those excluded from testifying were persons who held peculiar religious beliefs or had no religious beliefs, and so were not bound by an oath, the parties to the suit. A husband or a wife of the parties to the suit, persons who had a pecuniary interest, naturally incapacitated persons, and those guilty of certain crimes. Most of these exclusions have been removed, but under certain circumstances a person may claim privilege, and hence is not forced to testify. For example, a person accused of a crime may testify, but if he wishes to refuse he may do so, and his refusal cannot be used as the basis of an inference against him. Communications between attorney and client and other similar associations which relate to matters of professional employment are privileged. An attorney is neither compelled nor permitted, without the consent of his client, to disclose communications which have been made to him. Communications between a husband and wife are privileged on the basis of unity of interest and the sanctity of the home. All persons may refuse to testify as to state secrets. Expert opinion. It is an ancient rule of law that inferences are for the jury and that a witness must testify concerning the facts only, which for the purpose of evidence relate to something capable of being known through the senses, such as sight and hearing. It follows as a general rule that the opinion of a witness is inadmissible, but expert opinion constitutes an exception to this rule. Such evidence is admitted only on matters which the jury, being composed of average men without special training, are incapable of judging without assistance. Two questions are involved in determining its admissibility. First, does the subject matter require expert opinion? And secondly, is the person who is offered as a witness an expert on the subject? The first is based on the assistance which the testimony will give to the jury, the second upon the qualifications of the witness, in the field in which he claims to be an authority. While the two best known subjects of opinion evidence are handwriting and sanity, the law recognizes experts in other fields if they are skilled through special study. The testimony of experts is contradicted only by the testimony of other experts and leaves the jury in the position of deciding which to believe. The most usual method of presenting the opinion of expert witnesses is by means of the hypothetical question, which relates to the result that would follow from certain assumed facts. As an example, if a physician is on trial for the negligent treatment of a crippled child, certain symptoms can be enumerated and an orthopedic specialist can be asked what treatment he would give, but the specialist is not allowed to offer his opinion concerning the negligence of the other physician, nor can he be asked for his opinion of the treatment given, according to the evidence which he has heard in court. These are facts on which the jury alone must decide. Legal and social evidence. Probably most people have less understanding about court procedure and evidence than almost any other division of the legal field, and therefore more readily form unfair conclusions. This is even true to a large extent of the group who are familiar with the methods of gathering, evaluating, and interpreting information in the fields of science, medicine, and social work. The aim of all these groups is service to individuals who need help because of some crisis in their lives, and medicine, social work, and law move toward this end by means of certain processes of research, interpretation, and treatment which differ somewhat in method but are similar in many ways. Medicine and social work base their interpretation upon more flexible data than law, and the decision may be delayed for the factors change from day to day. It is this same flexible quality which makes it difficult for social workers to understand the difference between social and legal evidence. It should be understood that if the latter must be presented in a way which seems rigid and unsocial in its restrictions, it is largely because the customs which developed from crude beginnings have hampered progress and made it hard to break away from tradition. Furthermore, if law is necessary in order to control the conduct of individuals in society, the facts reported by means of evidence must be accurate, as they form the basis for a final and permanent conclusion.